All right, we're going to go on the record on cause number DC181432A. Counsel, make your appearances.
Lauren Jobin for the plaintiff, Renisha Gamble.
And Jeff Strauss for the defendants.
All right, we're here on a few motions today, as I understand it. We're here on plaintiff's motion to compel, plaintiff's motion for leave, and defendant's motion for summary judgment. Pursuant to the settings of the clerks, we're going to go ahead and start with the plaintiff. Ms. Jobin, you may proceed.
Okay, Judge, this is a case where I had substituted in as counsel for Brian Mincher, and Jeffrey and I had had a number of conversations over, I think, in December regarding the fact that there was a lot of discovery that I thought that I needed them to supplement, right? And those would that would be relevant to my claims regarding, negligent training, negligent supervision, all that kind of stuff, right? So we had discussed on, I think it was 12/31, and Jeffrey had said, I'm gonna be supplementing that here in the near future or something like that. And then, I never got anything supplemented. And then, as what ended up happening is, it was kind of, we're going to try to get to mediation on this kind of thing and hopefully reach a resolution. Well, about 2 or 3 weeks before the mediation, they filed this MSJ against me, getting rid of all those claims, but it never supplemented discovery. So I got a response from Jeffrey stating, I kind of like, but we've been talking about this over time. This isn't a new development, right? This has been going on for some time. And then his response was that we would need a confidentiality. They want to have a confidentiality agreement for this stuff. Now, some of this stuff I don't think is subject to any kind of confidentiality agreement, first of all. But I will say that, filing the MSJ when they haven't timely supplemented or produced documents that would be relevant to those claims, I think, unfortunately, is kind of a gotcha tactic, quite frankly. But there's a ton of them, okay? And they go to Kevin Hogan, who's the driver. Now, my understanding is that Landstar Ranger Incorporated and then Landstar Holdings, I think Landstar Ranger is the one that's going to have most of the information, right? I think that Jeffrey and I have kind of discussed that. But I have gone on, I've had a FOIA response to a FOIA request on this company. And I mean, they had a critical 395.8E violation for hours of service compliance on February 9th of 2018. And I mean, 420 wrecks and tons of violations in the last 2 years. So all this stuff would be relevant to those claims, right? And I don't have any of that information. Now, they retained a safety expert, which is kind of counterintuitive if they're not wanting me to have any of those claims, right? They just want it to be under respondeat superior. Well, when they designated him back in the beginning of kind of December, I'd said I need to take his deposition. Well, obviously, I'd said I need these documents in order to effectively take his deposition. You can't, it's kind of having your cake and eating it too. You're going to retain an expert for it. So all of this information I need. Now, obviously, for me, I need to add a gross negligence claim, which is why I filed the motion for leave, but I still don't have the documents. So if we want to go through these one by one, we can, but I mean, I think the most relevant ones are going to be to Kevin Hogan, the driver, and Landstar Ranger. But he's kind of saying he wants this confidentiality agreement. But some of the questions on Kevin Hogan were, did you have a cell phone number and a cell phone and we need the provider and that kind of stuff. That wasn't answered. Have you been involved in any other motor vehicle collisions? That wasn't answered. I mean, that stuff is not That's not subject to any kind of confidentiality agreement. I haven't seen a proposed confidentiality agreement asserting what exactly they're saying is proprietary or what is not. And, you know, we were attempting to try to resolve this, and we did actually have mediation. I think there's a proposal out there that expires at 3 p.m. today. But I don't have any of these documents. So that's why I'm saying it's kind of all interrelated. So I don't know what they're saying subject to, but I think you have an obligation, and obviously we try to resolve these things outside of having to go in front of the court and have you sit here and go one by one by one, which I exhausted those, you know, those trying to do that. And then I never got anything supplemented. So that's kind of the situation that we're in right now, is I need these documents, which is where the motion for leave, because based on what I'm finding just on my own, without them producing anything, leads me to believe, and the evidence in the case, that there may be a gross negligence claim. I think there is a gross negligence claim. So that's kind of where we're at right now.
Response?
Yes, Your Honor. I'm going to try to keep it limited to the motion to compel issue, which is, I believe, the first motion set. So the motion to compel issue, Ms. Jobin is correct. She's substituted in, I don't know, maybe November, October, something like that. And she did request supplements of discovery dating back to December, and which I'm always agreeable to review our discovery responses, seeing what, you know, especially when I have some kind of inclination onto what they think that they're entitled to or what's relevant that wasn't produced initially. I'm always happy to do that and see what we can supplement. So I say December 31st, yes, we'll look at my discovery responses and supplement, you know, what we can. I reached back out to her after the new year, and from that point forward, it was radio silence. I couldn't get any response regarding what discovery issues they had with our responses or objections, what documents they needed, depositions. I provided dates for depositions, no response, no response. So I really was left with no other recourse regarding the depositions. I couldn't leave our expert in Florida with a date on his calendar. I couldn't get a response from plaintiff's counsel saying, yes, let's go forward with that deposition. On these written responses, we have supplemented, Ms. Jobin referenced prior accidents for the driver. We supplemented that information the day after, or before they filed their motion to compel. The day of their motion to compel was a Wednesday. That was when this COVID stuff was ramping up. And that's the first day, I believe it was March 12th or 11th, first day that she said that I even received a draft of a motion to compel that gave me any idea of what issues they had with our interrogatory responses or RFP responses. That day, I told her, okay, now that I know, I'm happy to supplement. And I did. I supplemented interrogatory responses with cell phone numbers, with cell phone provider, with prior accidents, prior traffic violations, all that stuff's been supplemented. That was done on March 13th, no, March 12th. So all that's been supplemented. On the RFP responses, Judge, they've issued, I believe it's 79 RFPs to a driver, Landstar Ranger, and Landstar System Holdings. We have a verified denial filed on behalf of Landstar System Holdings because they're not a proper part of this case. Their 79 RFPs encompass virtually every document ever created in Landstar Ranger's business. Those aren't, to say, oh yeah, we can go through every RFP, that would virtually take up a week to do if we want to go through every 79 RFPs and get the court's ruling. We have stuff, the confidentiality agreement I referenced would pertain to the training materials. There's proprietary information in there regarding the Landstar Ranger that they're entitled to have protected. That's what we're referencing. We've already produced the driver's logs. We've already produced their driver qualification file. All that stuff has Kevin Hogan's orientation information, his employment history, everything that was needed, was relevant from the get-go. We produced long ago. This case has been on file for a year and a half. I mean, it's been a long time. Trials set in June 2nd. We're not trying to hide the ball or anything like this, but on these discovery responses, we literally could not get a response from anything until we filed MSJs right before our spring break.
Ms. Jobin, he says that he's supplemented a lot of this. Have you looked at his supplementation?
I've looked at I've looked at some of the supplementation, but it's still not the documents that are relevant as to the company's policies. And that I will tell you that I asked in December 20th that they identify a corporate representative with knowledge of company safety policy so that I could take their deposition. And on that same date, I requested dates to depose their safety expert. And Mr. Strauss I know that you had communicated with my paralegal about this. And I believe that one of the things that you had said was that the dates that I would be able to take those depositions, I think you gave one date in February that did not work with my schedule. And then and this was where we were going to have to travel, but I still didn't have any of the training documents. Now, I was not under the impression at any point that you needed me to specifically identify you. I said there are a lot of things, and you said, okay, I will get, in the near future. You never said to me, oh, okay, I need you to identify boom, 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 boom. Now, on the corporate representative, you gave, I think, a date in Florida, and it would be in Florida, and it didn't work with the schedule. Then you said it looks like we're not going to be able to get these scheduled until after the mediation. I know that conversation occurred. So that would mean that it would be after the mediation, which just occurred, 2 weeks ago. So then, I have been asking for this since back in December, and a date was provided. I disagree with the fact that this has been a situation where there's just been crickets over from our offices. And there have been things that have been done. And, I'm saying I need that hiring. I need those documents. And I was under the impression that we are going to try to, if we can't get this case resolved at mediation, was the communications I thought we'd had, then okay, well then we're going to have to take these depots, we'll get this stuff done. And then this MSJ gets filed, if you understand, Your Honor. So that's where I'm a little confused.
What it sounds like to me needs to happen is that you two need to sit down and kind of go through all of the different discovery requests that are outstanding and figure out what needs to be produced, what needs to be subject to the agreement. And for me to rule on this, especially remotely, it's hard enough to do this in person, but remotely, I'm going to need a checklist order of everything that I still need to rule on. And the checklist order should have each particular request that there's a dispute about and what the request is. And then am I going to, have these been objected to, these requests? Not been answered.
They've been objected to.
Anyway, if there's an objection, I need to have either the objection's overruled or objection is sustained. And then if there's other discovery issues, I need to look at those as well. So, and then I think we also need to get some dates for the deposition. When is this case set for trial?
June 2nd.
It doesn't sound very likely it's going to be able to be reached. Do we need to reset this trial setting or no?
My motion for leave, Your Honor, also, and our response to the MSJ includes a motion for continuance to allow this stuff to occur.
Mr. Strauss, what's your thoughts on that? Well, our initial thoughts is that this case has been going on long enough. So, I mean, that's our position. Like I said, I mean, the deposition she referenced in Florida, that's our retained expert, trucking expert, who opined in direct conflict with the investigating officers, who says that a commercial motor vehicle can never enter a no truck lane. That's what our expert was retained solely to do. He wasn't retained to opine on any other issue other than that. So because the investigating officers had bad information on their training in that regards.
What about the corporate rep?
The court, well, when we can't designate a corporate rep, and I don't think the rules require us to until we receive a list of topics. We've never received a list of topics for any corporate rep depot. We've requested that, but we haven't gotten it.
I have not received a request for a list of topics. I identified on my own, even though y'all didn't identify a corporate representative with knowledge of safety policies. I went through the discovery you had produced and discovered that and then also by going through the FOIA responses, the person that was sent this critical violation and seems to be responding on behalf of Landstar seems to be this guy, Mike Cobb. So I just identified him myself and want to take his depot. I never got a response to a person that would have knowledge of company. I sent an email saying, can you identify a corporate representative with knowledge of company safety policy, supervision, and training on December 20th. I then just identified Mike Cobb myself because I didn't get a response to that and requested to take his depot because I need to take his depot because the way they're running this company, and we'll get into the, evidence in the case on the lane truck, but that I need to take his depot, but I need documents before I can do that so I can take an effective deposition of him and explore those topics on, negligent hiring, supervision, or whatever their training policies are that were pled.
Mike Cobb was the one who was the gentleman. He's the vice president of safety located in Chicago. He's the one who signed the verification to our verified denial on behalf of Landstar System Holdings. Without a list of topics, there are a number of employees at Landstar that have knowledge regarding any topic related to anything that Ms. Jobin wants. Just because Mike Cobb authored a verification doesn't mean he's our corporate representative.
I think you get to choose your corporate representatives. Okay, this is what I'm going to do. I'm going to go ahead and reset this case for trial. How does September 1st sound? Is that, well, you want to take a look at your calendar?
Yeah, let me see what mine looks like.
Is this working remotely going to be over by then, Judge?
I hope so. God, I hope so. Well, if they're not trial settings, if there's not jury trials, then obviously we're resetting everything, which we've done so far. But
yeah, it looks like for lead counsel on behalf of the defendants and myself, is that the day after Labor Day, or is that the next?
I think it's the Tuesday before Labor Day.
Okay, yeah, September 1st works for the defendants.
It looks like it works for me too.
Okay, so we're going to reset this for trial to September 1st. Rhonda, go ahead and get out a new trial notice for this. And then this judgment after you've had an opportunity to confer. I know things are a little more difficult right now with the pandemic. So do you want to look at 2 weeks from now, maybe 2 Fridays from now, or next Friday? Or how long would it take you to confer and give me a checklist order?
I mean, I could probably do it by next Friday.
What did you say?
Yeah, I can do it by next Friday. That's fine.
Okay.
April 10th?
Yes.
So Rhonda, reset this to April 10th. And let's do that at, how does 10:30 sound?
Oh, you know what? Hold on a second. Let me make sure that's not, I think for some, hold on. No, I'm good. Okay. Yeah, I'm free April 10th. That works for me. Same time?
I think he said 10:30.
Okay. Is he frozen? Oh, no, there you are.
Yeah, you guys look frozen. So,
Yeah, okay.
Did you say next Friday worked or not?
Yeah, yes, it does, Your Honor, yes.
So, and Mr. Strauss, does that work for you?
Yes, Your Honor.
So next Friday at 10:30, we'll go ahead and reset this. If you're able to either settle the case or work all of these issues out, please leave a message with my court coordinator, Rhonda, to let her know that the hearing will be canceled. But otherwise, we're resetting all of the hearings except for the motion for continuance from this week to next Friday.
Okay, so that pertains to the motion for leave and the 2 MSJs.
Yes.
Okay, thank you, Your Honor.
All right. Anything else, guys?
Not at this time.
Not this time.
All right. We're going to go ahead and pause the recording and end the live stream.